You might know that there has been rapid forward movement in priority dates since October 2020 except in August 2021 Visa Bulletin for few of categories. And such movements have been creating curiosity among applicants to know more about the future processing trends, especially when fiscal year 2021 is ending. In today's video we will discuss and get to know about September 2021 and future, fiscal year 2022, Visa Bulletin predictions directly from U.S. Department of State official Charlie Oppenheim. For our new viewers, if you are wondering, who is Charlie Oppenheim? Actually, he is the one who issues the Visa Bulletin each month and fixes the dates on the bulletin. In today's interview, Charlie will answer to various important questions such as how long the rapid forward date movement will continue to be, how India's EB2 and EB3 priority dates movement will be in September 2021 and in the fiscal year 2022? Will there be any retrogress to current dates and much more? If you are interested in any of these topics, please stick around till the end of this video for your immigration updates. If you are liking this video, please hit the subscribe button, like this video and click the bell icon so that you can instantly receive any new updates right on your YouTube home page of your smartphone or smart devices. Before we move further, recently we have released the August 2021 Visa Bulletin analysis. If you haven't watched it, please watch it from link given at top right corner of your screen. Now let's start the interview. Here is first question. I submitted all of my documentation to NVC a long time ago and I have confirmed on their website that everything is completed correctly. My priority date became eligible in March, but I have not yet been scheduled for my final visa interview. Why haven't I been scheduled despite the eligibility, and when can I expect to be scheduled?
A question we've been getting a lot, both for this purpose and in the visa office as a whole. It's important to say that throughout the COVID-19 pandemic, the NVC has continued to schedule appointments and is warehousing cases for consular sections that have not been able to resume their routine IV processing. And depending on the country's local restrictions and resources, the consular sections abroad provide their projected capacity for scheduling to the National Visa Center about 30 to 60 days in advance. This allows NVC to begin scheduling those appointments and get the information out to the applicants early. Other than age-out cases, inter-country adoption and expedites based on certain FAM regulations upon visa availability, the NVC schedules our immigrant visa appointments for visa categories in chronological order in which the date the case was deemed documentarily qualified, meaning they had been asked to submit certain required documents. All of those documents have been received and have been verified. Then our National Visa Center fills the available appointment slots in a first-come, first-out manner within each visa class in accordance with each consular section's capacity. I'd advise listeners to refer to the guidance on the NVC IV Backlog Report website to view the worldwide data count of applicants which have been processed by NVC, and then that'll determine how many have become documentarily complete. So again, NVC and the overseas posts are trying to get to all of the appointments and applicants as quickly as possible. It's been being done in chronological order, and basically they're having to catch up on cases that could have been scheduled as far back as March of 2020.
Okay, let's see the next question. Do you expect the India EB3 final action date to reach January 1, 2014 application filing date which had been announced earlier this year?
Yes, the India third preference final action date for September will be announced at January 1, 2014.
Sure. Let's see the next question. Do you have any information regarding the amount of unused fiscal year 2021 family and employment numbers?
During the past these past YouTube events, I've mentioned that both State Department and USCIS are doing everything possible based on their respective processing capabilities in an effort to maximize number use in both the family and employment and diversity visa categories. I can tell you there's been a significant increase in the amount of family-sponsored number use at our overseas posts during the past 2 months, and therefore I have lowered my previous estimate of unused family numbers slightly, and now believe there'll be approximately 150,000 unused family numbers. On the employment side, the USCIS use of employment numbers continues to increase. It may not be at the levels many people would like, but it is increasing and they're doing their best. But I do believe there could be approximately 100,000 unused employment numbers. Again, the COVID-related issues, which have had a dramatic negative impact on the processing of fiscal 2021 cases, continues to make providing these estimates very difficult. But again, I can assure everyone that every effort is being made by State Department offices and USCIS offices to maximize number use under the respective annual 2021 annual limit.
Great. Let's see the next question. In the last session, you mentioned that almost all application filing dates of October 2020 Bulletin had been reached by the final action dates in 2021. That is not true for family-sponsored categories. Can you explain why?
That most of the application filing dates announced in October 2020 had been reached. I was responding to a question about the employment-based preference categories. In the employment preference categories, except for the India EB3 application filing date, which was subsequently retrogressed, all of the employment application filing dates have been reached or exceeded, and the retrogressed final action date for the India employment third preference category will be reached in September. In terms of the family-sponsored application filing dates, the difference is that approximately 95% of the family cases are processed overseas. The application filing dates, which were announced last October, were based on our hope that overseas posts would be able to provide processing and return to a somewhat normal operational status much earlier than has been possible during fiscal 2021. Therefore, conditions have prevented our returning to those dates.
Okay, let's see the next question. Can you provide any insight into the movement of family-sponsored final action dates for October and beyond?
Except for the Mexico and some Philippine dates, little if any forward movement can be expected in the family dates during probably the first 3 to 6 months of fiscal 2022. This estimate is based strictly on current conditions and the current Immigration and Nationality Act guidelines versus the amount of demand which we currently have. Again, the family dates which have been established this year would, in a normal time, have maximized number use under the annual limit, and therefore we're going to have all this demand, quote, pent up, ready to go come October under the next fiscal year's annual limit.
Sure. Next question is, the Appropriation Committee's Fiscal Year 2022 Homeland Security Funding Bill contains an amendment to recapture unused fiscal year 2020 and 2021 visa numbers. What would be the impact of such a proposal?
I'm very aware of this proposal and have analyzed it, but I'm not at liberty to discuss the impact of any proposed legislative action. In part, even if it were passed, ultimately passed, proposed language is often changed before the final bills are enacted. So it would not be prudent of me to make any comments at this point.
Okay. Let's see the next question. Many of the employment-based final action dates have been advancing at a rapid pace this year, and I am wondering if we can expect the dates to become current as happened in July 2007?
The answer is a definite no, based on the current potential level of applicant demand, which could utilize numbers under both the family and employment annual limits. There is no need for additional changes to categories to make them current if they are not already current.
Great. Let's see the next question. How do you determine if and how much you will advance the final action and application filing dates?
This is always, I think this is kind of a repeat that's from one of the early events, But when I'm making the determination of the final action dates for an upcoming month, I consider variables such as how many numbers have already been used, how many additional numbers may be used in the current month, and how many numbers remain under the various annual limits. I then look at the amount of demand which has been reported to my office at that specific time, then compare the total with the numbers which I want to have established as a target for number use in the upcoming month. I have a very similar process for determining the application filing dates, but there I am estimating how much additional demand I may need to be generated in the next 6 to 12 months in order to maximize number use. So I will, if I were to move, say, the September application filing dates, it's so that I would generate numbers which I think will be required under my respective targets for number use 8 or 6 to 12 months in the future. That's why there was such a dramatic increase forward movement of many of the employment final or application filing dates last October. It was done on the anticipation that we were going to have a certain amount of numbers, potential demand for this fiscal year. And therefore we will do the same process going into the next fiscal year.
Okay. Let's see the next question. What are the chances of EB3 India filing date getting to August 2017 next fiscal year?
They're talking about the EB3. There is no, I see no reason to expect that the India third preference final action date would reach 2017 in the foreseeable future.
Okay. Let's see the next question. Will the rest of the world make progress for the 4th of August?
Some of the worldwide dates may advance slightly for September, along with some of the Mexico and potentially the Philippines fourth preference date. All may advance slightly for the month of September. And then, as I stated earlier, I believe a significant period of time can be expected for the rest of world final action dates to be holding as we enter into the early part of fiscal 2022.
Sure. Let's see the next question. In the July Visa Bulletin, there are approximately 7-month difference between filing dates for the Indian nationals and for the final action dates. How the State Department does anticipate the processing of the remaining cases in the 7 months when current USCIS processing times for I-485S is between 13 to 50 months?
The USCIS portion of the question, people would need to contact USCIS to find out about their processing times. But we do, as I stated earlier, we look at the application filing date movement in terms of how much demand we believe needs to be generated in order to meet future number use demands. At this point, the amount of applicants in the weekly groupings for both the India employment first, second, and third preferences, all of them are very heavy filings in the various weekly groupings. So it is necessary to have significant large movements of the application dates. Often we get plenty of demand by moving it 1 or 2 months at a time. People that have been long-term viewers of the Visa Bulletin will remember that there was during fiscal 2018 and fiscal 2019, and many times, for example, the India second preference date was moving literally days per month forward movement, not a full week, not a full month, but literally 2 to 3 days at a time. So again, the amount of applicants in the India employment categories is significant in the weekly groupings.
Great. Let's see the next question. Are the spillover visas allocated only in the last month of the fiscal year?
Early in the year that we would have unused numbers, I can start dropping them down to be, or moving them around to be used in the various categories earlier than the final quarter. For example, based on my discussions with the USCIS officials, I was able to determine that the amount of worldwide demand in the employment first preference category was going to be insufficient to fully utilize all the fiscal 2021 numbers. So very early in the year, I started allowing those otherwise unused numbers to be utilized in the China and India employment first preference categories. I subsequently determined that we were still, even with that happening, there were going to be unused numbers in the employment first preference category under the worldwide limit. And at that point, I started dropping them down for potential use in employment second preference categories. So again, I can make the determination at any point in the year. And for certain categories, I often do it as early as October based on historical trends. And then the only risk of making numbers available earlier in the year is if conditions were to change that may require some type of corrective action. And typically, one of the questions we are often asked is about dates retrogressing. Mm-hmm. Typically, it is the best, the likelihood of retrogressions occurring are typically in August and or September.
Right.
The reason is I know that when I were to retrogress a final action date, that can cause turmoil for cases which were in current stages of processing, maybe very close to the end. It's not good for our overseas post, USCIS processing, or the applicants. So I fully realize the implications of doing so. So I typically wait as long as possible before doing any type of corrective action. And then if at all possible, I try to do a complete recovery to the latest established final action date for the month of October, so there will be as little disruption in the processing of cases. And we make these adjustments can be made at any time, and we always make our decisions based on the best information at that specific time. Again, an example of this is when the India Employment Third Preference application filing date was established last October. It was deemed that the date needed to be out to January 1st of 2015 in order to generate a sufficient amount of demand. The amount of India Third Preference filings in the month of October and November far exceeded the amount that the Immigration Service had expected. Therefore, it was necessary to retrogress that application filing date to limit future filings. So again, we're constantly looking at patterns so that we can attempt to maximize number use each year.
All right, thank you.
Okay, let's see the next question. Given that EB3 India final action date has moved forward by 1 year and 9 months in fiscal year 2021 with one pending Visa Bulletin left, is it fair to expect that at least the same movement in fiscal year 2022?
It would be too early to speculate on that. I will have to consult with the Immigration Service regarding the amount of pending demand of cases that they have on file already in active processing status and compare that with the amount of numbers which will be available for next year. So by maybe when we have this event next month, I may have a little bit more insight on to that question, but at this point it's a little bit early.
Thanks. Let's see the next question. In July 2007, the Department of State made all EB2 and EB3 cutoff dates current for all countries. Is the Department of State considering actions like this for this year given the anticipated wastage of green cards?
No, the answer is mentioned earlier, and this is one of those, I must have seen probably 50 of these questions come in to the advanced questions. And again, the answer is no. The difference between 2007, at that time, there was not sufficient demand on hand at that particular time to utilize the numbers. Therefore, the categories were deemed to be current. This year, there is sufficient applicant demand on hand in both the family and employment categories. to fully utilize the fiscal 2021 annual limits. Therefore, except for those categories that are already current, there is no need to make anything else.
Sure. Let's see the next question. Can we expect all regions to be current for DV visas in October 2021?
No. All of the the DV 2021 regional rank cutoffs are current. I do not believe that will be the case in October. Typically, we start off the year and proceed through at least through the first half of each diversity visa program year, having some type of rank cutoff. Then, as we proceed through the latter part of the year, if I see that the demand for numbers appears that it will be less than the annual limit, then we go ahead and make the categories current. I believe I made for the 2021 program, I think that all the DV categories became current for July, and all but 2 countries may have become as early as May or definitely June. So again, we go to current in that situation to maximize number use because the amount of respondents is insufficient to utilize all the available numbers. And I can tell you that the amount of DV applicants who have submitted all of the required documents for this fiscal year is probably under 50% of those that were actually notified. So again, it's incumbent upon applicants, if they want to act on their case, they really need to do so in a timely manner and not wait for their visa availability, whether it's in the family or employment or diversity category. If they're asked to submit documents, it is in their best interest to do so in a very timely manner.
Okay. Let's see the next question. Can you provide any insight for dates movement for employment based for fiscal year 2022?
Somebody might have tuned in late. I do not expect drastic movements in any of the employment final action dates at least in the first quarter. And then we will kind of have to see again. That comment is based on the current situation and my anticipation that there will be a significant amount of unused numbers from this year, which means that applicants who are in active stages of processing with USCIS, their cases hopefully would be finalized early in fiscal 2022, thereby kind of negating the need to make early movements of the dates, or at least any significant movement of the employment final action.
Sure. Let's see the next question. Will EB5 and China final action date continue to move forward in September 2021?
It will possibly move a week or 2 for the month of September, and then it is likely to hold for an extended period of time. The Vietnam has already become current. It will remain current. So at this time, I anticipate going into fiscal 2022, the only employment 5th preference final action date would be that being applied to China employment.
Okay. Let's see the next question. Why is the EB2 to EB3 downgrade process time very slow with EB3 progression dates ahead and EB2 behind? It feels unfair for EB2?
Well, it's based on the amount of EB2 potential demand, and it must be remembered that if an applicant has filed in the employment 2nd preference category, and their case has been basically pre-adjudicated in that category, it appears that it would be there. It remains demand there. The fact that the applicant has requested a downgrade to employment 3rd preference, in the report information which is received in my office and I use for the determination of the final action dates, that 3rd preference downgrade only becomes apparent at the time it is finalized and they're ready to adjust the person as an employment 3rd preference. Therefore, since right now in recent months, the amount of 3rd preference demand I have ready to go is less than my targeted amount available for the upcoming months. That's why I've been able to advance the China third preference at a faster pace than I have the second. And the same holds true for the India employment second downgrades to third. We've been able to move the India third preference at a much faster pace than India second.
Sure. Let's see the next question. If you finish reducing the backlog for one category, would you give more numbers for another category?
Yes. The way the employment category distribution of numbers is laid out, any unused employment first preference can fall to employment second. Any unused second can fall to employment third. Any unused, potentially unused employment fourth and fifth preference numbers, they actually fall up to the employment first preference category, thereby increasing that limit, and then the fall down takes place. Then what I do is in each individual preference category, starting with employment first, I look at the worldwide limit. Say that the annual limit happened to be, say, 60,000 numbers, and for example, China and India say that they were entitled to 4,000 each. That means they're entitled to 8,000 of the 60,000 limit. If I determine at some point that the rest of world demand for the remaining 50,000 numbers is insufficient to utilize them, then I could begin allocating any of those otherwise unused numbers can be made available to India or China strictly in priority date order. And that is what's done. And that's done whether it be the first preference, the second, the third, the fourth, the fifth. It applies to all the various categories. So, and that is done because the congressional intent to make sure that numbers may not be wasted in a particular category just because there wasn't sufficient rest of world demand, yet a country such as China or India may be able to fully utilize the numbers.
Great. Let's see the next question. What circumstances have changed in between June and July in which Mr. Oppenheim has changed course and now expects the wastage to be very large?
I think they're misunderstanding something that was maybe mentioned in an earlier calls. I had previously said that number use was maximized in fiscal 2020. At the time, I mentioned that there were only approximately 9,000 numbers unused under the 2020 limit. And in normal processing years, most of the employment numbers, the annual limit are used, and we reach the annual limits or very close. I have been for several months stating that there were going to be significant amounts of unused employments numbers, potentially, and as well as the large amount of family preference numbers. I believe at one point I said that the amount of unused family numbers was going to make the fiscal 2022 employment limit potentially well in excess of 290,000. So again, I haven't said that they were going to use all the numbers before. I think that may have been misinterpreted on when it was referring to previous fiscal years.
Sure. Let's see the next question. Do you expect EB3 final action date or filing date to reach January 1st, 2016 and October 2021?
Again, I'm assuming this is related to the India preference category second. Yeah. Again, I would not expect reaching a 2016 India second, definitely, or an India third preference likely in fiscal 2022. There's just too much India second and third preference demand at this time, I believe, to be able to reach that type of a date.
Sure. Let's see the next question. What will be the dates of filing for EB2 and EB3 in India in October 2021?
Lean heavily on what you see listed as application filing dates for the month of September. We may, again, I consult heavily with the USCIS officials on a monthly basis and making determination if there is a need to be advancing the application filing dates. And this is because the Immigration Service typically does at least 85% of the employment number use. So they're the key player, keeping me informed in terms of the amount of filings they have, both the I-140s, the filings for I-485s, et cetera. But again, pay close attention to whatever is listed in September and use that as a kind of an idea of what may happen. And in past years, typically the Immigration Service will allow the application filing dates to be used for it during October, and typically at least for 2 or 3 months. I believe there was only 1 year when they did not allow the filing dates to be used, but in other recent years, they've allowed them to be used anywhere from through November to through January.
Thanks. Let's see the next question. How does an applicant know if their application is documentarily qualified? Can an applicant check their DV status somewhere online?
And I am not super familiar with the process that is done, but in recent years, applicants have been able to upload their information that is requested by NVC directly to an NVC website. And once that is done, the applicant is able to track the status of their case throughout the process, and they can see at any given point where their case stands in the NVC processing. That process also allows NVC, if they had notified me to submit certain documents and I forgot to submit a birth certificate, some other type of information, they are able to respond to me quickly and say, Charlie, you forgot your birth certificate. We need that for your case to potentially become documentarily qualified. So again, cases that have been filed and are being processed by NVC in recent years, there is a link on the NVC website. I'm sorry, I don't know the direct link, but if you go to the NVC section, the applicants should be able to find it. And I would imagine that instructions on how to track the status of the case may be included in the information that NVC sends out requesting that information.
Mm-hmm. Yeah.
One other thing that reminds me, it is always, if applicants say they change their mailing address or their email address, if it's different than they filed when they originally filed their petition and all, it's very important to always keep the National Visa Center informed of that change so that they can correctly correspond with the applicant, because they're going to send information or try to contact people based on the information, the latest information they have. And I know that in the old times, when more of the things were transactions were occurring through the mail, often applicants would move and they would not notify the State Department of their new address. They may have thought that, okay, they would notify the Immigration Service and they would notify state, but they really needed to be contacting state to let us know about any changes of contact information.
Sure. We have few more questions. When do you expect the dates on the worldwide F4 adjustment dates to move again to be able to be docked to DV documents?
The worldwide family fourth preference dates have been advancing throughout the year. Maybe not as quickly as they had last year or at the very beginning of the year. The Philippines dates and the Mexican dates fourth preference dates are not advancing at a very rapid pace. But I think, as I said earlier, I think that what you see for September is likely to be what you're going to get family-wise for rest of world for the next 3 to 6 months. And again, Mexico to some extent, and possibly Philippine family dates, they may continue to advance somewhat, but Rest of world, very limited, if any.
Okay. Let's see the last question. When a visa number actually considered utilized by the Department of State? Is it when USCIS approves the case or when the case is documented or documentarily qualified?
It varies on we allocate numbers, blocks of numbers on a monthly basis for our use at our overseas post. For example, we've already provided a block of numbers for the applicants who are being scheduled for interview during the month of August. That number is either used for visa issuance, or at the end of August, it would be returned to our offices in Washington and put back into the pool of numbers available for the upcoming months. This is one of the things where I say, when I'm making the determination of the final action dates, I have to take a lot of variables into consideration, because I'll be doing the September dates in early August. I'm going to have to estimate how many of the block of numbers that I gave out already for August, how many of those will be used and how many may be returned, in the same consideration for September. In terms of the USCIS, if a case has been filed with them and they've actively been working on it, they may have interviewed the applicant, but between the time when the applicant originally filed their I-45 and the case was ready for final adjudication, the applicable final action date has retrogressed, then they can go ahead and request a visa number, but it is going to go into our pending demand file for future use, because it is the applicable date at the time of final action on the adjustment of status governs the use of a number, not what was available when it was filed. But say that an applicant were at the Washington District Office today being interviewed, and they deemed that the person was eligible, fully eligible. The USCIS officer would enter certain required information into their computer. They press a button and they get an immediate response from my office indicating that either a visa number has been authorized, which is typically what happens, or in the case, as I mentioned, if the date had retrogressed, it goes into the pending demand file. But at that time, when they do the request for the final action on it, at that time when we authorize a number is reduced from the amount available for the fiscal year.
Thanks, Charlie. We will see you next month, once September 2021 Visa Bulletin is out. I hope you found this video helpful. We will release new video when more updates are available. U.S. Immigration Updates channel is dedicated to provide every information, visa processes that are required for your U.S. immigration journey. It is important to know about the United States immigration processing steps, visa application requirements, processing times, forms, fees and more. We will continue to provide every information for U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, H1B, student visas, green card, immigrant visas, EB1, EB2, EB3, EB4, EB5 and family-based immigrant visas. Thank you for visiting us today. We will see you in next video. If you haven't subscribed our channel yet, please subscribe our channel for more videos on U.S. immigration updates.